My name is David Sobel, and I'm a real estate and finance attorney here in Michigan. Today's question comes from Susan Ross of Grosse Pointe, and she writes that last year I entered into a private road agreement with my next door neighbor, who at the time of the signing was down in Florida for the winter. We agreed to sign on a separate copy of the agreement. We both signed in black ink, and now less than a year later, my neighbor says that the contract is not valid and that she never gave me the copy with the original signature. So quite frankly, I can't tell if her signature is the original or if it's a copy because, again, she signed in black ink. What are my rights? Well, whether or not the contract is still valid depends on quite a few items, Susan. First, let me just say, for all practical purposes, when it comes to signing a document with either blue or black ink, it's kind of personal preference until it's not. And what that means is that blue ink makes it easier to determine which document is an original and which document is a copy. However, in many real estate transactions, real estate recording offices and title companies will request that the people who are signing, or the signers, do so in black ink because it photocopies better. And if the documents aren't going to be signed, if the documents aren't going to be recorded, then I prefer to use blue ink. So not every contract that I deal with on a daily basis gets recorded with the Register of Deeds, only those that relate to real estate. Now, with regards to the validity of the separately signed contract, when there are multiple parties to a contract, it's best to insert a counterpart clause into that contract. And this is a good idea when parties are located either in different cities or states, or they can't, they're just not able to attend the actual signing of the contract in person. So allowing for a counterpart clause means that parties to a contract actually agree that the signed copy of a document is as good as the original document itself. So they don't need to sign the same original document because the clause itself indicates that they're both agreeing, or the parties are agreeing to be bound to that same document, even if it's on a separate copy of the document. So for instance, you could have three different signers located in three different states, and they're all signing on three separate copies of the same document. That's fine. With the counterpart clause, each copy or each signed copy could actually be combined to make one valid contract. And courts will actually honor that separately signed agreement. And when there is that counterpart clause, a few still will do so without the clause, but why would you ever take a chance without it? So it's my inclination to advise clients to always have a counterpart clause included in the contract. In your case, Susan, your neighbor can actually raise a defense against the contract and its validity because of all the original signatures were not found on a single document, and you did not have the appropriate clause. It certainly is going to make the legal action to enforce the contract a little bit more difficult. Anyway, so you should remember that it's always best to have a real estate or contract attorney review your documents, and like all legal agreements, you should have them reviewed. So I encourage you to see and like more of our videos concerning real estate law and contract law at provenresource.com. I'd also request to feel free to leave your comments and share your feedback about this video and the other videos that we produce. And definitely write in the comment section what legal topics that you are interested in and what you're concerned about. And that's pretty much it. So thanks for watching. I'm David Sobel, real estate attorney and finance attorney. You can also reach me at 888-789-1715 or at provenresource.com.